All right, settle down, everyone. Welcome, KSLU students. Open your notebooks right now. I'm your professor for today, and listen carefully. This explainer isn't just some casual discussion. This is your definitive masterclass on Islamic jurisprudence. Today, we're tackling a massive fundamental question: discuss the sources and development of Muslim law. I need you to pay your utmost attention, because what I'm about to present to you on these slides is the exact blueprint required to score maximum marks for a 16-mark question on this very topic in your finals. If you follow this structure exactly, you'll leave the KSLU evaluator absolutely no choice but to award you full credit. So here's our agenda for today's course. Number 1, Introduction to Muslim Law. Number 2, Development Phases. Number 3, Primary Sources, Divine Rule. Number 4, Primary Sources, Human Reasoning. Number 5, Landmark Case Laws. And finally, number 6, Secondary Sources and Conclusion. Kindly memorize these exact 6 subheadings, all right? The KSLU evaluator will be specifically looking for this exact structure in your answer script. Okay, let's dive right into Section 1, Introduction to Muslim Law. I direct you to write this introduction as your first primary heading, in capital letters right at the center of your answer booklet. Establishing a strong introduction sets the academic tone immediately. Look at the board. Muslim law, or Islamic law. It's a personal law system of divine origin. It is derived from teachings of Prophet Muhammad, based on a combination of revelation and human reasoning. It governs matters such as marriage, inheritance, and family relations, and it's broadly classified into primary sources and secondary sources. Let's dissect this dual nature. On your exam paper, I want you to heavily underline the terms divine origin and human reasoning. This is the absolute crux of the matter. The law isn't static, you see. It's anchored in divine revelation, but it is navigated through careful, deliberate human reasoning. Highlighting those 2 exact phrases will fetch you immediate marks from the evaluator. Moving on. Section 2, Development Phases and History. Let's look at the timeline. 570 to 632 AD is the Prophetic period. 632 to 661 AD is the period of Caliphs. 661 to 900 AD is the Classical period. And the modern period brings us to the present. Let me remind you, a chronologically sound answer reflects a well-prepared mind. You must draw this exact timeline in your answers to show the evaluator you actually grasp the linear progression of Islamic jurisprudence. Early development phases. First, the Prophetic period, 570 to 632 AD. Law derived directly from Quran and teachings of Prophet Muhammad, who was the final authority. Next, the period of Caliphs, 632 to 6061 AD. During this time, caliphs interpreted law after the Prophet's death, and they began using consensus, which is Ijma, and reasoning, which is Qiyas. Now, you must explain in your answer how the physical death of the Prophet necessitated this historic shift. Direct divine revelation had ceased, which meant authoritative interpretation by the caliphs was strictly required to actually guide the community. Then the later development phases. The Classical period, 661 to 900 AD, saw the development of fiqh, which is Islamic jurisprudence. This era led to the emergence of the major schools, Hanafi, Shafi, Maliki, and Hanbali. Then we have the modern period, defined by adaptation and partial codification, and continued application in personal law matters. I'm explicitly directing you to write those 4 schools of fiqh, Hanafi, Shafi, Maliki, and Hanbali, in distinct, separate bullet points on your exam sheets. Don't just clump them together. Clarity of presentation equals clarity of thought. All right, let's dive into the heavy lifting now. Section 3, Primary Sources, Divine Rule. Prepare yourselves, students, because this is the most critical section of your Bare Act analysis today. If you fail to explain the Quran and the Hadith accurately, your entire answer collapses. Quran, the holy book of Islam, containing revelations from Allah to Prophet Muhammad. Mark my words and take this with the utmost seriousness. This is the absolute, supreme foundation of the law. It's not merely a source, it is the ultimate origin point from which all Islamic jurisprudence flows. Look at the role of the Quran. It's the supreme and primary source. It lays down rules relating to marriage, divorce, inheritance, and crucially, all other sources must conform to it. I want every single one of you to put a massive asterisk next to that phrase, all other sources must conform to it, in your notes. When you write this in your exam answer, it definitively highlights your understanding of the paramount, unchallengeable authority of the Quranic text in this legal framework. Our second divine source is the Hadis, or Sunna. It consists of the sayings, actions, and approvals of Prophet Muhammad. Now, while the Quran is the direct word of God, you must explain to the evaluator that the Hadis is the practical, living examples set by the Prophet during his lifetime. It's the translation of divine will into human action. Role of Hadis: it explains and supplements the Quran. It provides practical application of principles, and it's used when Quran is silent or ambiguous. You've got to ensure you demonstrate a strict hierarchy here. The Hadith doesn't override the Quran. It is only invoked when the primary Quranic text is silent on a specific modern issue or when it requires further practical elaboration. Moving right along to Section 4, Primary Sources, Human Reasoning. This is where your understanding of juristic interpretation really comes into the syllabus. We're shifting from divine decree to human intellect now. Ijma, or consensus. Consensus of learned jurists on a point of law. Now, what's really interesting about this slide is the sheer power of scholarly agreement. When individual interpretation isn't enough, the collective, unanimous agreement of recognized legal scholars solidifies into binding law. It's a powerful mechanism for legal certainty. Let's read the role of Ijma. It ensures uniformity and certainty. It helps resolve new legal issues. And once accepted, it becomes binding. Listen to me. I absolutely demand that you write the phrase "becomes binding" in capital letters in your answer booklets. You must show the evaluator that you completely understand the finality of an accepted ijma. It's not a suggestion, it becomes the law. Next is Qiyas, or analogical deduction. Application of law by analogy. Read that word distinctly. Analogy. That's the core mechanism of Qiyas. It's the strict legal process of comparing a brand new problem with an old problem that already has an established divine ruling. The role of Qiyas. It extends principles of Quran and Hadith to new situations. It's based on reason and logic, and it helps law remain flexible and adaptable. So the crucial point here is that Qiyas ensures Muslim law doesn't just stagnate. It remains a dynamic, adaptable framework, capable of addressing contemporary legal challenges through highly structured logical deduction. Wake up, class! Section 5, Landmark Case Laws Analysis. Pay very close attention, because this specific section right here will determine whether you get an average 10 marks or the full 16 marks. First up, Ahmed Khan v. Shah Bano Begum. The Supreme Court emphasized that Muslim law must be interpreted in light of justice, equity, and good conscience, showing the evolving nature of its sources. Now for the mandatory deep dive. I command you to write this case name in a separate, distinct, boxed format on your answer sheet. Make it impossible for the examiner to miss it. Underline this case name to immediately capture the evaluator's attention. The brief facts: Shah Bano, an elderly woman, was divorced and claimed maintenance from her husband. The core issue was whether the secular provision of Section 125 of the Criminal Procedure Code regarding maintenance applied to Muslims, overriding limits set by traditional personal law. The ratio decidendi, the final verdict of the court, was that Section 125 CRPC applies to all citizens, totally regardless of religion, to prevent destitution. The absolute relevance of this case to our topic is that it spectacularly demonstrates the evolving nature of Muslim law when it intersects with modern statutory law. It proves that principles of justice and equity remain incredibly active interpreters of these sources in modern Indian courts. Next case, Rashid Ahmed versus Anisa Khatun. The Privy Council relied on classical sources of Muslim law to determine validity of divorce, highlighting the importance of Quran and traditional interpretations. Box this case law as well. The facts here are vital. A husband divorced his wife via the irrevocable triple talaq, but later they resumed cohabitation without the intermediate marriage, known as halala, which is required by strict traditional law. Naturally, the legitimacy of their subsequent children was questioned. The ratio decidendi of the Privy Council was to strictly uphold traditional validity. They ruled the divorce was legally final the exact moment it was pronounced, rendering the subsequent cohabitation invalid under classical law. Why does this matter for your 16-mark answer? Because its absolute relevance lies in proving the continued rigid adherence to classical sources and traditional interpretations when determining fundamental questions of personal status. It perfectly illustrates the enduring power of those primary divine sources we discussed. Finally, we reach Section 6, Secondary Sources and Conclusion. Secondary sources. We have custom, or urf, judicial decisions, and legislation. These supplement the primary sources. Maintain your deliberate, focused academic pacing here in this final segment. But I'm advising the classroom right now, these should only be briefly mentioned at the very tail end of your answer. They are strictly supplementary materials. Do not waste pages on them, as the primary marks awarded by the evaluator are heavily concentrated in your analysis of the primary sources. Look at these application steps. 1. Quran provides the foundation. 2. Hadith explains it. 3. Ijma ensures consensus. And 4. Qiyas introduces flexibility. This slide brilliantly illustrates the exact logical flow of authority that a sitting judge or a jurist must strictly follow when applying Muslim law. You literally cannot jump to Qiyas without first exhausting the Quran, the Hadith, and established Ijma. And we conclude with this: Muslim law, a comprehensive legal system that maintains a balance between divine authority and human reasoning, ensuring relevance across time. Write this conclusion exactly as it is. It ties the entire 16-mark answer together perfectly. As you finish up your notes, I leave you with a final thought to ponder as prospective lawyers. As our society rapidly modernizes, how will this delicate, centuries-old balance between strict divine decree and adaptable human intellect continue to be tested and harmonized in the modern Indian courts of tomorrow? Think about that. All right, class dismissed. Study hard.